So let's proceed with your appearances.
Good morning, Your Honors. Steve Maurer, along with my partner Alex Falzine, here on behalf of Appellant Sue Wichman, and I'd like to reserve 3 minutes for rebuttal.
3 minutes, you've got it.
Pat Reardon, and with me is Lauren Marquis, Reardon, Fincher, and Mayo, who represent the Appalese, and Flint Hills, and so on.
Thank you, counsel. This is Sylvia Sue, is it Wichman? Wichman, appellant versus Bank of Flint Hills and Silver Lake Bank. Counsel, let's hear from the appellant.
May it please the court. Again, my name is Steve Maurer. I'm here on behalf of Appellant Sue Wichman. She is here present in the courtroom with us. I understood the court has read the briefs and familiar with the facts, so I'll dispense with the lengthy discussion. Suffice it to say that Ms. Wichman in 2024 was the victim of a scam.
Was it in 23?
Well, yes, Your Honor, in 2023. And in that scam, she was bilked out of $690,000, her life savings. That money was withdrawn personally by her face-to-face from the two defendant banks, Bank of the Flint Hills and Silver Lake Bank. Sometimes I'll refer.
Isn't the nub of this whether there was some duty owed by the banks to Ms. Wichman in August and September of 2023?
Yes, Your Honor.
Okay. What is, and you obviously contend there is such a duty. What is the source of that duty in your view?
The source of the duty is that the banks knew she was being scammed. The banks have a duty, like any other Kansas business, that if in transacting business with a customer, my transaction is putting that customer in greater peril, in greater harm, and I know it, then I have a duty to act on that harm. I have a duty to protect my customer.
Okay, I mean, that's a common law duty, right?
Yes, Your Honor.
All right. And it seemed to me in the brief, unless I'm mistaken, I mean, what you relied on, though, premises liability cases, primarily.
Yes, Your Honor. The seminal case that establishes the duty of a business in Kansas is Siebert versus Vic Reginier Builders. And
well, how does that translate, though? I mean, I'm having a hard time seeing how the duty a business owes to keep the aisles clear of debris and spilled items and stuff like that. Premises liability translates into an obligation of a lender to deal with a particular transaction.
the difference, Your Honor, is the evolution of our commerce. America's commerce is not today conducted just at a storefront where you have to make sure the aisles are clean and there's not water on the floor. In fact, in Siebert, the criminal act that which the duty was owed arose in a parking garage, not even connected to the premises. But as the Supreme Court said, if the business knew that, or should have known, that there was a danger posed to their customers, they could have a duty to act. And the importance of Siebert is two things. First of all, the court acknowledged that there's no case on point. There's no reason, there's nothing that says, yes, the banks or the business can be liable. However, the court allowed discovery to go forward, and based upon the totality of the circumstances, the totality of the evidence amassed, the court said there could be liability. And the court and the summary judgment that was granted for the business was reversed, and it would go back. And so
Bank 4 versus Capital Federal inform a duty here? And if so, how?
Thank you, Your Honor. I so wanted to talk about Bank 4. The Bank 4 case, you really need to look no further than to find why this case should not have been dismissed at the very beginning of its case. Bank 4 was ruled on summary judgment. The fact pattern of Bank 4 was a one-time event where a bad actor came into the bank, presented a durable power of attorney, and was allowed to withdraw all of the funds of an elderly person who may have even been deceased at the time of the transaction. The court, in that analysis, did an extensive discussion of the durable power of attorney and what the purpose is, and then said specifically, is there a duty to investigate by the bank? And the court said, No, because of the durable power of attorney. That's what a durable power of attorney is for. If I've got a durable power of attorney, then that person can go in and transact business from my account.
Well, didn't the court say that there was a duty to investigate, but it was limited to 3 things particular to the power of attorney?
Yes, Your Honor. The court said that if a power of attorney is involved, then there is a duty to investigate. What the court in Bank 4 did not say is there's never a duty to investigate. If a bank never had a duty to investigate, there would have been no reason for the Supreme Court to spend 9 pages discussing the power of attorney. They specifically found, and it's page 544, that there is no duty in this case based on the facts and circumstances herein.
Counsel, let me ask you a question. What forms the basis for this duty? I can see when there's a physical presence and that's visible, there's a duty to warn and duty to fix it. And even in Bank 4, you've got a durable power of attorney, which is a piece of paper that you have to make sure that it's valid and all of that. But where is it here? What circumstances give rise to a duty by a bank? Or is there just something in the nature of a bank that creates a duty? I'm trying to understand your theory.
Sure. I have 2 answers, Your Honor. First of all, the nature of the facts in this case, which we never got to develop through discovery. But what we do know, and we pled, is that Sue Wichman was an elderly widow, very conservative, well known in her small town of St. Mary's, Kansas, personally known to the bank. They knew that if Sue Wichman had $1,000 in her purse, it had been there for 6 months.
What about the fact that she went to multiple branches? Does that change the scope of those facts?
No, Your Honor, because she was allowed to withdraw the cash, and the fact that she went from one branch and took out $50,000 and then went to another branch and took out $40,000, the banks had a duty to communicate so that they would have known, and it's impossible for me to believe that, and we would have found in discovery that the banks didn't have a system to communicate from one branch to the next to know that I've got an elderly widow withdrawing tens of thousands of dollars of cash day after day after day. Your Honors, if the banks or any business in Kansas is dealing with a customer that they know is not in their right mind, that they know does not have capacity, that they know is being improperly influenced, they have a duty to just say, no, I'm not going to transact business with you. In fact, Your Honor, it is not uncommon for banks to put a stop to any transaction that they think is suspicious. I have a debit card in my wallet. That debit card when I use it, it's a withdrawal from my account on deposit at the bank. It's a deposit account. Just the other day, I got a warning from my bank. We've seen a suspicious activity. Is this you? Did you make this transaction? We are not going to authorize it until we investigate whether or not it's a legitimate, well-intended transaction.
And isn't that ultimately what put a stop to this? Is that?
Yes, Your Honor. When the banks finally asked, after $690,000 had left their doors, when one bank officer finally said, hey, wait a minute, what's going on here, Sue? Why are you withdrawing all this cash? It stopped. So there is no dispute that if the bank would have acted when they should have at the very beginning, or certainly after the first $50,000 left the door, it would have stopped.
Looking at this from what the law was in, again, August and September of 2023, what is the source of the duty or the authority that you suggest the banks had to pause or stop the transaction? Can you cite me a case that says a bank had the authority to do that?
I don't have a case that says they could do it. I certainly know that they should do it, and they do it all the time, as my example with the withdrawal from my debit card. Banks have that authority, and in fact, they have the obligation, both common law and statutory, to investigate and ask the question.
Well, I guess I'm asking, you're saying that, but what do you base that on? And what do you base it on, particularly in the petition and the pleading here, which is what we're dealing with?
Yes, Your Honor, a bank has an obligation to inquire when a cash transaction is being made and a duty to report. If a cash transaction report, that's a CTR. It is their obligation. They also have to inquire in order to satisfy the requirements of an SAR, which is a suspicious activity report. They have to make that investigation. They have to do it. It is their obligation to do it.
Obliged by, under some banking rule?
Yes, under federal statute, Your Honor, it is required that if cash transaction over $10,000, they must inquire to then determine if they need to make a suspicious activity report. They never inquired. There is no doubt they never inquired. Now they might tell you, oh yes, we did, but it's not in the petition. We pled they did not ask. And most importantly, we pled when they finally did ask, this is paragraphs 41 through 44 of our petition, when they finally did ask, the scam stopped. So yes, they had the obligation to ask. And if they would have asked, it would have stopped.
But you're not alleging negligence based on violation of federal banking laws, right? I mean, that wasn't pled.
Correct, Your Honor. I'm just saying the question, as I understood the question, it was, where is this obligation to inquire arise from? Well, it arises from not only common law, but also under federal banking laws, you ask questions for a suspicious activity report, and you have to make a submission on a cash transaction report. Those things are required. And so because of that, they have that obligation. Let me get back to the Bank 4 case very quickly, Your Honor, because I think Bank 4 answers these questions. Bank 4 did not say there is no duty to investigate. In fact, the Bank 4 Supreme Court went through a litany of cases, both from Kansas and other states, specifically saying that if the bank knew or should have known, they can be liable. They looked at New York law, Texas law, Tennessee law, Missouri law, and in the Georgia case that they discussed, they specifically noted that if the bank had knowledge that makes them an accessory to the act. That's specifically quoted on page 550 of the Bank 4 case. Here, the law of Kansas has always been a bank has a duty to investigate unless there is something that exculpates that duty, like a durable power of attorney, which is the only thing that Bank 4 turned upon. Otherwise, it's all about knowledge, the same as the Siebert case, which is if a business knows, then it's their obligation to do something.
Before you sit down, I wanted to ask you about House Bill 2591 that went into effect July 1st of this year.
Yes, Your Honor.
Does that in any way inform the duty that we're looking at as it existed in 2023?
I think it does, Your Honor. The House Bill 2591, I believe, is a follow-up to the Financial Elder Abuse Act, which was in place. What both of those acts were intended to do was to eliminate any sort of excuse or reason why a bank would not act. Both of those acts, 2591 specifically says, bank, if you make a report, you're not liable. You're immune from anything that might happen. If you put a pause on an account, you are not liable. You cannot be sued for putting a pause on an account, trying to protect elderly Kansans.
Okay, but how does a piece of legislation that went into effect this year have anything to do with the duty as it existed 3 years ago?
Because what the House Bill 2591 does not say, it doesn't say that if you don't act, you're not liable. It doesn't create the immunity that the banks might try to suggest, and it is instructive as Bank 4 looked at, as the Bank 4 Supreme Court looked at. They looked at the durable power of attorney statute and said, there is public policy supporting the use of durable power of attorneys. This is what our Kansas citizens want. The Financial Elder Abuse Act and House Bill 2591 are representative of what the Kansas citizens want and expect, which is banks to protect their customers when they know they are subject to danger. Thank you.
Thank you, counsel.
Thank you, Judge. May it please the court. As a preliminary matter, as we go through all this, I just want to point out, we're dealing with a motion to dismiss. So consequently, we agree to everything being correct because that's the standard. There's been discussion, the pleadings in the district court, that we're admitting to things or agreeing to things. No, we're just saying that in the 117 paragraphs made in the petition for a motion to dismiss, we're assuming those to be correct because that's the appropriate standard. And our point is that even under those 117 paragraphs,
Used to be called a so what motion. We agree with you, but so what?
exactly, that if, and so lay it all out, tell us everything you think, it won't matter. And the reason for that is we kind of get to a very basic concept. When we talk about where does this duty arise from, what's the relationship, we all have to remember that this is a deposit account. And every deposit account gets to go into the bank and say, give me my money. And they have the right to get that money. It becomes who is entitled to control that money. That's where the account owner is so crucial. And that's where Bank 4 really comes into play. You can't engage in a narrow distinction to say that's about a power of attorney, because what Bank 4 really is saying that if somebody comes in to take the money and it's not the account owner, you need to look at the power of attorney to make sure that they have the same authority that the account owner would to take the money. But what happens when they say, no, you can't have it? Well, then they're going to have to prove that the durable power of attorney was incorrect, the bank will, to justify not paying over. But when it's the actual account owner in person coming into the bank to say, I want this money, that is the authority to take that money.
Well, Bank 4 doesn't say that though, does it?
Right. And we mentioned that in our brief, Your Honor, that it doesn't stand to reason that the issue was you have to make sure that the person trying to withdraw has authority, which is how Bank 4 can be read in a lot of ways. It doesn't stand to reason that if you already know this person has the authority because they're the account owner, then there's no duty to investigate because they're entitled to that money.
But my bank tells me I can't use my credit card all the time on my, my checking account because they're flagging suspicious transactions. So how can you say there's absolutely no duty beyond you're the account holder, you're due your money?
Because the question that arises, Your Honor, where is that authority that you can unilaterally say no as a bank to anybody coming in with an account holder? Now, debit cards, that's a direct draw against the account. You also have credit cards. Those are actually extension of credit. So that's a little bit different. But just because some banks inquire, other banks don't, doesn't create the actual duty that if somebody comes in and says, I want my money, they're entitled to get my money. And I would add,
You would agree that Bank 4 recognizes a duty.
to make sure it's the authorized withdrawal.
Okay.
Well, you've got other duties as well. You've got the duty of safekeeping. You've got a duty to pay interest. I mean, it's not your money. It's not the bank's money.
Right.
But you've got custody of it. So you've got certain responsibilities that way.
And which is why, Your Honor, in the court raises a point. I'll just do a quick side move in here real quick. A lot of these withdrawal issues are cases out there. If you look at them, a lot of them do deal with the failure for safekeeping. A lot of them are a hacker getting access to the online account and withdrawing all the money from the online account. Or it might be a hacker calling in and saying, you need to wire this money to this bank account. Or somebody comes in and says, I am authorized to withdraw. That's where a lot of the safekeeping cases and duties come from. But in this case, none of that was here. She actually came in and said, I want my money, which raises the issue of if you want your money, there's really no authority right now for the bank to say, you can't have it. Even if you want to do the dumbest thing in the world with your money, it is your money. Which is why I believe the new House bill, Your Honor, is very important from that aspect in terms of what was available then and what was available now. Because if you refuse to turn over money when it's asked for, just like a check, everything else, if it's there and if you think there might be a problem, you then still have a problem. Under the rules of privacy, you can't really tell anybody. I would add that there's really no, if you look at the briefs, there's no authority that says you have to inquire for an SAR or any sort of federal reporting obligation. There are federal reporting obligations, but you don't inquire, particularly if it's an SAR, because you don't want to tip
I
off
want to
the
go back
veterans.
to
Yes.
Bank 4.
Yeah.
It seems to me it recognizes a duty, they call it a duty to investigate, but a duty to inquire when there is an unusual transaction involving an individual account holder. That happened to be CDs in that case, but I don't think that
Right.
makes any difference. Isn't that the duty that it recognizes?
I think the crucial distinction is that investigation was as to the power of attorney.
Well, is it confined? It's not confined to powers of attorney, is it? I mean, those were the facts. And
Yeah, and I believe that's what the analysis of the court was, that as long as you can show that they are authorized to take the money out, it's their money. So at what point does the bank impose a informal guardianship or conservatorship upon the actual
well,
person?
yeah, but you're trying to cast it as a duty to refuse the transaction. It seems to me that's different from a duty to inquire. And that a duty to inquire would not have been onerous in this circumstance because Ms. Wichman was present. It would not be difficult or burdensome to ask her why she wanted $50,000 in cash, which based on the petition was a bizarre transaction for her.
The duty to inquire, and again, we're dealing with what the facts of the petition allege. So to that extent, if under the petition, there's no discussion about the bank asking the account holder an inquiry about this, well, then that's the allegations that we will deal with. Although I think
Well,
the
I'm
petition,
not, but I'm asking about the nature of the duty. I mean, there is Bank 4 recognizes a duty, and I'm trying to figure out what that duty is or why that doesn't apply here.
well, the duty in terms of inquiry, I don't think Bank 4 is talking about, again, I mean, we'll put aside the issue. I think that doesn't apply to the account holder that shows up and says, I want my money. If somebody else shows up and says, I want their money, that's different. But if somebody shows up and says, I want my money, there's no case law that says the bank has to even ask, what is it for?
Let me ask you,
That's right.
let me ask you along the same line
Yeah.
in a different way. In the Bank 4 case, you're presented with a power of attorney. Is it a duty for the bank to inquire? Is that valid? Is that instrument valid?
Correct.
So is that only the only duty of inquiry?
If you look at the 3 points under Bank 4 that says what a bank's supposed to do for the inquiry, I'd say yes, because you want to make sure that that power of attorney is correct.
But the nature of the relationship between the customer and the bank is essentially the same, correct?
Correct.
So if there's a duty to inquire in that circumstance, I think Judge Atchison is asking, is there not a duty to inquire in other circumstances as well, when it's just simply large cash withdrawal?
No, Your Honor, because the duty to inquire in Bank 4 is the duty to ensure it's authorized. The account holder showing up and saying, I want the money, that is being authorized.
Okay.
And then furthermore, you get into what do you do if the account holder says, I want the money? Because you don't know what people want money for or what they're going to do with the money. They have the absolute right to take the money and be gone with it. But in terms of being able to do anything outside of inquiry, well, then that's why the new act is somewhat important to show what the law is now, to give some authority to stop a transaction or to bring other people into the mix and to breach privacy laws, essentially, to inquire further with third parties, but more importantly, to stop the transaction. But if the court looks at that new act in terms of the grounds for stopping the transaction, it says you can't do it just based upon the number, the amount, and the account holder's desire to get the money. So the law is probably clearer now than it was previously in terms of what a bank could do. But if a bank, but before this act, if a bank, somebody comes in and says, I want my money, and you inquire, and you may think it's suspicious, and you refuse to give the money over, and it was for a legitimate reason, they just don't want to tell you about, or what they told you was a legitimate reason, then you're in trouble for not giving your money, the
Well, let me
account holder's money.
pose two scenarios. I mean, let's assume that someone like Ms. Wichman, not her, but someone like her in that situation, goes in and asks for $50,000 in cash. And that's an unusual transaction. And the teller says, well, you know, that's unusual. What are you going to do? She said, well, I want to go to Las Vegas and gamble. Okay. But let's say, again, similarly,
Mhm.
the response is, well, I've been contacted by a federal government agent and I'm assisting in an investigation of child pornography. Now that's kind of weird. And the next question would be, well, do you have some identification or way I could contact that agent? And then it starts to unravel. I mean, that's just bizarre. That's a red flag of a scam. And ultimately, I suppose if the customer says, look, I'm adamant, I'm a big believer in stamping out child pornography and I'm going to do this, maybe at that point, the bank is powerless. But it has done an investigation, has suggested that this might be bizarre and weird and offered to check into it by contacting the agent. And it says, I don't want to do any of that, just give me my money.
Right.
Then I mean, I see where you are, and short of the changes by, House Bill 2591, maybe the bank is stuck at that point. But it didn't get to that point. And it seems to me that it's not unreasonable to suggest to a bank that it ask in the face of what is a highly unusual transaction for an individual customer, particularly one who might fall in a category of a customer susceptible to scams. And you're saying that that doesn't exist. There was no such duty in 2023.
Correct.
All
Under
right.
the law, there's just no authority for it.
Huh?
And if the court looks at the petition, and this, I got 2 minutes left, so if I could just address another issue, because this appeal is kind of morphed in some ways from what's the right of the account owner to the timing of the motion to dismiss. But if the court looks at the actual petition, there is discussion about what actually occurred, including some discussion about asking questions being asked. But more importantly, there is now a new discussion of discovery should have been allowed. And that's really the key here, because we followed our motion to dismiss on the facts as they were alleged, which we just don't think the way they go through everything states a claim under current Kansas law, or the Kansas law that was available back in 2023. The questions about wanting to do discovery and potential new cases and all that, that does get to the heart of the matter, which is when we filed our motion to dismiss, there's safe harbor provisions that you can redo your petition as a matter of course within 21 days of getting the motion to dismiss. And if you decide to double down and stay with your case, it's kind of too late. And this was discussed at the district court level, that once the court rules on the pending motion and grants it, you can't come back now and say, I want a do-over to amend my petition. That should have been done prior to your decision to stick with your case theory.
Wouldn't that's the question, whether it should have been with prejudice or without prejudice, right?
Yeah, sure. But even that's a little bit different, because with prejudice means the facts on this matter, what's alleged here, are with prejudice. But without prejudice, that distinction, if you were to find out later that there was a conspiracy or there are some other facts which generates a different type of claim, like in the Reardon case, you have somebody trust officer within the bank breaching their fiduciary duties, I don't think with prejudice actually prevents you from refiling. But it certainly is something that you're now kind of barred from the case that you brought forward and decided to stick with. My time's up, Your Honor.
Any other questions? All right, thank you, Counsel.
Thank you.
You still have your rebuttal, Counsel.
Thank you, Your Honors. I'm going to try and address just two things. Number one, the point that you were just asking about on the amendment of our petition and whether or not we should have done something after the motion to dismiss was filed. The transcript from the district court is very clear. The court found that there could never be a duty. And in fact, below, Bank's counsel was very good at convincing the district court any amendment would be futile because there is nothing they could do because we have no duty. We have no obligation because if it's Ms. Wichman's money, she's absolutely entitled to it. Therefore, there is nothing that could have been done. Hence, there was no amendment that would have ever satisfied the district court. Discovery should have been allowed because Bank 4, Siebert, and all the other cases they cite are summary judgment cases. They're not cases on a motion to dismiss. Finally, the second point, you posited two scenarios where Ms. Wichman comes into the bank and asks for $50,000 cash, very abnormal transaction. I'll give you one more. Ms. Wichman comes into the bank and asks for $50,000 cash, and the teller says, Ms. Sue, what do you need that money for? God's talking to me, and he says money is the root of all evil, and I need to burn it. According to the bank's arguments, their answer would be, here you go, Sue, here's $50,000 cash. To take it one step further, their argument would be, even if she took it out into the parking lot, put that $50,000 on the ground in full view of the bank, doused it with lighter fluid and set it afire, turned around, walked back into the bank and said, God's not satisfied, I needed another $50,000, they would have no obligation to do anything but give her $50,000. They would have no duty to do anything to try and stop and prevent the loss. That is not and cannot be the law of Kansas. If a business knows that their customer has something wrong with them, if continuing the transaction puts that customer in greater harm or greater peril, they have a duty to say no. That has always been the law of Kansas, and it's not limited to just premises liability. They have an obligation to stop. And all they would have had to do in any one of these transactions is say, Sue, what do you need all of this cash for? That's very unusual for you. I need to understand what's going on. And when that happened, after $690,000 was out the door, the scam stopped. Clearly, discovery will show, and this case should have never been stopped on a motion to dismiss because this court analyzes duty based upon the totality of the circumstances, based on all of the facts, which we never got to bring up, we never got to present, and therefore the district court should be reversed. Thank you.
Thank you, Counsel.
Thank you.
Well, the very interesting case, we'll take it under advisement and issue a written decision as soon as we can.